The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The spring meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law Section. My name is Anora Wang. Today's topic is what's on the radar? Legal and regulatory analysis of airline mergers in the United States. My co-host today is Kelsey Paine. Hi, Kelsey.
Hi, Anora.
So we're at a hot moment for airline mergers. We are interested in knowing what's going on in terms of legal and regulatory analysis. Is that what we're talking about? And is there anything more why we're talking about it?
Yes, so airline mergers have been in the news a lot lately, with the recent Alaska Air acquisition of Hawaiian Airlines and the failed JetBlue Spirit merger. This is an industry that experienced a lot of deal activity among larger carriers back in 2009 through 2013, and it seems like it could be picking up again today. So we're interested in what the regulatory review process looks like for an airline merger. Who conducts the review of the proposed deal and what criteria do they look for? How has the evaluation criteria changed over the years since the last wave of mergers? And what might this mean for the future of airline deals?
And who would be joining us in this very interesting discussion?
Our guests today are Courtney Dyer and David Heffernan. So Courtney is an antitrust partner at O'Melveny with extensive experience dealing with M&A before U.S. antitrust agencies. In addition to her M&A work, she counsels clients on matters including joint ventures, Section 8 of the Clayton Act, and information and data sharing. Courtney represented Alaska Airlines in its recent acquisition of Hawaiian Airlines and also counseled Alaska through its acquisition of Virgin America in 2016. She's a member of the O'Melveny team representing U.S. Airways in its merger with American in 2013. And Northwest in its merger with Delta in 2009. David Heffernan chairs the Transportation and Trade Group at Cozen O'Connor in Washington, D.C. Over his nearly 30-year career, his practice is focused primarily on counseling airlines and other aviation industry clients on regulatory matters. He advised Alaska Airlines on the Hawaiian Airlines acquisition and also Alaska Airlines 2016 acquisition of Virgin America.
That's a lot of deals experience that we have today. So our listeners, you're in for a treat. Without further ado, welcome, Courtney and David.
Thank you.
So to start, let's take a step back and first talk through the history of the U.S. airline mergers generally. I believe there was a wave of airline mergers that happened back around 2009, and now there seems to be a new wave. So how did the wave that began in 2009 shape the structure of the industry and potentially necessitate the current wave of mergers?
Hi, Kelsey. I'll take that one. And thank you to you and Anora for inviting us to be part of the podcast. We're excited to be here. So let's talk briefly about the four larger airline mergers that started around 2009, which led to kind of where we are today in terms of what we call the big four, the largest airlines that operate in the U.S. I think the first one was Delta Northwest, which happened at the end of 2009. Both Delta and Northwest had recently exited bankruptcy, and mainly from the effects of 9/11. The DOJ reviewed the transaction and closed its investigation after just 6 months, concluding that the merger was likely to produce substantial and credible efficiencies and not likely to substantially lessen competition. They saw the networks of both of the carriers as highly complementary, and there's lots of competitors out there on the routes that they serve, both legacy and low-cost carriers. So there was competition that they believe could restore anything that was lost as a result of the transaction. And then United and Continental quickly followed suit. They both exited bankruptcy as well and survived 9/11. And like the Delta Northwest transaction, the DOJ concluded that the airlines networks were largely complementary, meaning they flew to different cities, and resulted in overlap on a very limited number of routes where they both offered service. The one area that they had heightened concerns about was at Newark Airport, where slot constraints can limit entry or used to limit entry to new entrants. And Continental had a very large share of the market at Newark Airport. And so in order for the transaction to gain full clearance, the DOJ, required United and Continental to transfer these takeoff and landing rights or slots and other assets to Southwest. So once they did that, the transaction cleared. And then the next merger happened between two low-cost carriers. So these are not legacy carriers that had been around since deregulation, but what we call low-cost carriers have obviously lower cost structures than the legacy airlines. And the two that were merging in 2011 were Southwest and AirTran. Neither of them had been through bankruptcies. But the DOJ also cleared this one without any conditions because they did not feel that the merger would substantially lessen competition. There was some overlaps in the networks, but they found it compelling that as a result of the transaction, these two low-cost carriers could grow and start to compete head-to-head with the larger carriers. And they saw evidence when low-cost carriers came into these markets, prices were lowered. And so they were optimistic that going forward, looking in the future, Southwest and AirTran would expand their networks and compete more closely with the bigger carriers. There was also no airport restrictions on slots or gates at the airports that these two airlines served. And so two more airlines tried it again after that, and that was the U.S. Airways American transaction, and I think that was in 2013. Unlike the other three, the DOJ did not clear this transaction easily. They actually filed suit to block the transaction because they found significant overlap between their airlines and said they competed directly on over 1,000 routes where one or both offered nonstop or connecting service. They thought that the airline routes in which they served were already highly concentrated, that there were not a lot of other competitors on those markets, and the result would be the largest airline in the world. And as a result of this transaction, which happened to be the fourth in this big wave, would lead to an industry where 4 airlines would control more than 80% of the U.S. air travel market, and the DOJ did not like that industry structure. They were concerned, particularly at airports where there were slot limitations and entry by other carriers would be more difficult. But the parties did settle the transaction before it went to trial. And as part of that consent decree, the airlines had to divest slots and gates at 6 airports in the U.S., including DCA, Boston Logan, Dallas Love Field, to name a few.
Thanks so much for that. So the general public may think of the airline industry as being fairly concentrated already. Do you agree, or do you think perhaps the analysis should be more nuanced?
So as an antitrust lawyer, and I think just a lawyer generally, I think I have to answer it's always more nuanced than it might appear. But I will say the DOJ's prediction in the U.S. Airways American merger that there will be 4 airlines that control more than 80% of the market still stands true today. So they did get that piece right. So, if the industry structure is what it is with the 4 larger carriers, it makes it more difficult for smaller carriers like Alaska, Hawaiian, even JetBlue and Spirit from growing organically on their own, particularly in markets where the big 4 have a lot of strength and share, and that's typically in their hubs. So, why it's important for these smaller carriers to get the opportunities to grow through acquisition is to be able to offer customers convenience and utility, meaning they can fly their guests to more places they want to go at the times when they want to fly. This captures additional revenues for these airlines that they can funnel into organic growth, but it allows them to acquire loyalty from guests that will fly them time and time again, and that's really important. The Big 4 can do this at their hubs because they're located in the largest cities in the U.S., and they use these revenues to generate growth elsewhere. And in our case, and we can talk a little bit later about the Alaska Hawaiian merger specifically, we were looking for opportunities to enhance the airline's revenues to be able to grow and change the structure of the industry so that we could compete more effectively against the Big 4.
Obviously, there's a lot happening, and a lot of people are also watching. So let's actually get to the regulatory discussion a little bit. We want to understand who is in the regulatory landscape, or I guess since we're talking about airlines, the more appropriate metaphor would be the radar, I guess, as the title suggests. So which federal and state agencies, other than the DOJ, we may have hinted at already, are watching the radar, so to speak, meaning getting involved in the regulatory review of a potential airline merger?
So I can start on the antitrust side and then turn it over to David to talk about the DOT. You mentioned DOJ. Obviously, they have exclusive antitrust jurisdiction under the Clayton Act over airline mergers. So the FTC is never going to get involved in an airline transaction or an airline merger. But state AGs also play a role. And they've played a role in airline mergers since the first wave. They're very interested, certainly, in transactions that affect their local constituents and where they can fly and how they can get to different places. The state AGs, in some cases, get more actively involved in the DOJ review process. In some cases, they don't. My experience in airline transaction is they participate in the review and they seek waivers from the parties so they can communicate directly with the DOJ, but they haven't taken a lead role in a lot of the process that occurs during the regulatory review, meaning they may participate and listen in on a deposition. They may, review the information that you provide and attend the meetings, but they don't necessarily, they defer to the DOJ to lead the investigation and to do the analysis. Then private plaintiffs is just the other entity or the other group that I would mention before turning it over to the DOT. I think in nearly all of the airline deals, you've had private plaintiffs coming in challenging the murders under Clayton Act Section 7. They're typically filed in the middle of the DOJ review, and they often seek a settlement from the parties using the leverage of being able to file a TRO or a PI motion if the parties are close to closing. So you'll see those parties come in towards the ends of the regulatory review process.
That's literally hijack the merger. so right, maybe not in a literal sense, but David, so how seems obvious, right? This is a way of transportation. So DOT, which stands for Department of Transportation, seems to have a role, but what exact role that DOT has in the review?
So DOT does have a role, but it's limited. And a little history here may be helpful. Before the Airline Deregulation Act was passed, an agency that no longer exists, the Civil Aeronautics Board, had authority to approve or disapprove mergers. And after airline deregulation occurred, Congress transferred that review authority to the DOJ. And since that time, DOT plays a sort of a consultative role with DOJ on DOJ's reviews. They're available to assist, provide any industry-focused expertise and information that they have. DOT collects a lot of data on the industry, so they make that available to the DOJ. But it's really purely a consultative role. DOT does have a limited role of its own, which Congress left them with, which is the authority to review and approve or disapprove the transfer of DOT-issued certificates and particularly route authorities that the acquired carrier may hold. Under that scheme, a transfer of those authorities is deemed to occur upon closing of a transaction, upon the change in the ownership of a carrier. And DOT's statute on these route transfers states that DOT may approve one of these transfers if it's consistent with the public interest. And in a related part of DOT's statutory scheme, Congress gave DOT a set of policy considerations to decide what is or is not in the public interest. And those various criteria do include some competition-related points, but they also include a litany of other things that aren't particularly competition-related. They might be consumer protection-related or concerns about safety or air service to remote communities, many other things. So maybe I'll leave it there. I assume we'll get into a discussion later about Alaska and Hawaiian and provide a bit more color on how this actually works or has worked in our case.
Right.
Right. So, Courtney, I wanted to go back to the DOJ's review and focus on traditional antitrust analysis for a minute. How does the DOJ's review of mergers in the airline industry differ from the DOJ's review of mergers in other industries?
So that's a good question, and not much in the sense that it's still the same standard under the Clayton Act, but the TEA section, which I'm going to get this right, Transportation, Energy, and Agriculture section of the DOJ, has really deep knowledge of the aviation industry. They've looked at these mergers for a very long time. They look at other aspects of competition in the airline industry, and they're really experts on this particular market or these markets. So they start with a really good foundation in the industry structure, on the competitive landscape, airport infrastructure, entry, et cetera. And so, they come in, you don't have to do a lot of education as to what we're talking about before you can dive into the analysis of the specific transaction. And keep in mind, for good or bad, they have data and information and documents from all of the transactions and all of the issues that they've reviewed in the past, and they use them in the current review. So they've got probably more information at their fingertips than the parties have at their fingertips that they can use to kind of formulate their assessment of the transaction. But they're still doing the same thing as other industries. They're defining markets. They're looking at competition in those markets, assessing entry condition, engaging economists. So it's very similar in terms of the process.
And I know you talked a minute ago about how the state AGs conduct the review with the DOJ and how those might differ a little bit. But is there anything else you can tell us about how they work together or how the AG's review differs from the DOJ's review?
So they're still looking at it under the Clayton Act standard that the DOJ is. And so you're not necessarily, kind of separately, meeting, requirements of a particular state, a local act, for example, or a local statute. But they are very, they bring in maybe not necessarily the expertise in the aviation industry, but how the parties may impact the constituents of their state. And ours was a good example, the Alaska Hawaiian, because they're both very unique airlines that have historically served very remote communities, Alaska Airlines in Alaska and Hawaiian Airlines in Hawaii. And, the transportation infrastructure relies on both of those airlines to help residents in those states get where they need to go in the states when there's not roads that can get you there. So it's really sometimes the highways that these local residents are dependent on. So the Hawaii AG, for example, in this case, was concerned certainly with the same antitrust issues that the DOJ wanted to talk about, but was also wanting to ensure that there was a commitment from the airlines to continue to serve the local communities, to make sure that, residents of Hawaii can get from one island to another on using robust inter-island service. And Alaska didn't provide that service today, so there was no horizontal overlap per se, but it was really important for the local Hawaii AG to make sure that their residents were taken care of, and ensuring that the combined carrier going forward would continue to offer at least the same level of service to the residents as Hawaiian was today.
I think that's already a very rich background for my next question. So let's just drill a little deeper into the market definition exercise here, right? So you already talked about the Hawaiian and Alaska and how they operate in some more remote areas. So we know in the context of the air passenger services, we often talk about routes overlap, right? Or competition over specific routes in specific areas. But is every route created equal? Is a more remote route considered somehow more important, competitively than the other in terms of the status of competition that the agency might be worried about? So I guess all that comes back to the question, has the market definition exercise been different from case to case, at least in the deals that you have dealt with?
I think the consistency across cases is that they will always define a market as an O&D pair, right? They may have additional markets we can talk about.
O&D pair.
Or right. Origin and destination. So it's the city pairs. Right. So it's the route that the airline flies. So what they'll do is they'll take all of the routes that airline A serves and look at it compared to all the routes that airline B serves, and they'll say they look at nonstop and connecting. But I think just the starting point is always to look at where do both of the airlines serve, where do they serve passengers through nonstop service, and are there other competitors on those routes? So when you say is there a difference between a remote route and a not remote route, a remote route is likely going to have fewer competitors operating on that because it's probably the demand is not there to warrant other service. But they're looking at HHIs and the level of market concentration, and they're seeing if they've got the presumption of anti-competitive harm on those routes based on market shares and who else is there. So in addition to the O&D pairs, they'll look at, they'll look at airport level shares. We talked about in the United Continental transaction, they were concerned about Newark. Because Continental had such a big share of that market. It doesn't mean that a passenger going to Newark is always going to, one route is interchangeable with the next. They're saying if you have such a share of a market, it's going to be harder for others to enter and be successful in those markets. So they'll look at whether the airport has any sort of infrastructure limitations like slot controlled airports or airports that have gate restrictions or airports that are incredibly congested and gates are just not available for other airlines to come in. But just like in other industries, going back to your earlier question, they're also looking at things like labor markets, right? That's something that they're still interested in regardless of the actual industry that they're focused on. So they will, define markets more broadly in kind of non-traditional antitrust ways.
Right. So applying this specifically to a merger you both just worked on and the Alaska Airlines merger with Hawaiian Airlines that was recently completed in September 2024, what did the DOJ look at specifically there?
So as we mentioned, they'll always look at the O&D pairs, right? They'll look at where Hawaiian flies and where Alaska flies nonstop service. And there were 11 of those routes where both Hawaiian and Alaska served nonstop. Outside of those routes, the airlines networks are very complementary, and that's just not something that an antitrust lawyer defending the transaction will say. Hawaii only operates to and from Hawaii, and they fly certain routes to the mainland, but they also serve international routes to Asia Pacific. In contrast, Alaska serves mainly out of the Pacific Northwest and the West Coast, and they do have, flights heading east from those locations, and they have certainly flights to Hawaii, which is where the overlap comes in, but they don't have wide bodies. So they didn't have wide bodies, and so they didn't have international flying. So if you looked at a map and you put Hawaiian's flights next to Alaska's flights, you would see lines going in different directions, but there were still 11 routes that both airlines served nonstop that the DOJ did want to talk about. But in our case, these were airports where there was not infrastructure limitations. These are West Coast airports and airports within Hawaii that aren't gate or slot constrained. And they were all airports that were served heavily by the Big Four. So the airlines had competition already. And when I say Big Four, just to clarify, it's American, United, Delta, and Southwest. They all serve Hawaii, and they all serve Hawaii from the West Coast in addition to other places. So in terms of entry into the routes where there was more concentration, these bigger airlines were already operating within those airports, and they already had service to all of the airports in Hawaii. So, we felt and we advocated that even though there was overlap and there was a lessening of competition at certain of these airports, there was choice and there was the ability of larger carriers to come in and replace that competition. And I think I mentioned this before, DOJ also looked at Alaska's commitment to inter-island service, as did the Hawaii AG. And again, this wasn't because there was horizontal overlap. Alaska didn't serve the inter-island markets at pre-close, but because Hawaii residents were uniquely dependent on air travel, there was discussions about ensuring that service continued after the transaction. And it was a compelling part of the rationale for the transaction. And we were able to show that it's important for us to continue to serve those markets after the transaction. And then finally, I think the other big bucket was, because neither airline really had robust global service, they relied on international partners to get their passengers internationally. And so the DOJ did review partnerships that the airlines had with others to fly internationally and how that might change incentives going forward. So those were kind of the three main buckets.
That's very helpful. And just to give the listeners a bit more context for another recent merger so that we can talk about specific issues that the DOJ might be looking at in terms of like competition related concerns. So in another somewhat recent matter, as in July 2022, JetBlue had announced its proposed acquisition of another airline, Spirit, and then that was challenged by the DOJ in several states, and they actually eventually brought the case to court. And after litigating, I guess including a 17-day trial, which is a long trial, that ended with the district court blocking the deal, the parties eventually abandoned their deal in March 2022. So that's sort of a different story, different ending at least with the Hawaiian Alaskan matter that we just talked about. So Courtney and David, what did DOJ look at in that matter in terms of Spirit and JetBlue merger?
So I wasn't directly involved in the case, but from what I was able to glean is the DOJ was focused on the uniqueness of competition that Spirit brought to the routes that it served. They certainly looked at the nonstop overlaps, which were a larger number than the Alaska Hawaiian deal. And they looked at who could replace that lost service, right? Not just with entry, but also with expansion of existing service. And Spirit, again, reading from public sources, Spirit, the uniqueness that they brought was their low fares and providing service to communities that may otherwise not have service but for Spirit. And while there were other low-cost carriers that could expand and even announce that they would expand to some of the markets that Spirit was abandoning, they weren't large enough to cover all of the markets where there was a lessening of competition. So the DOJ did not think that there was sufficient entry or expansion by other airlines to fully replicate what Spirit offered. And I think there was about 40 nonstop overlap markets that were presumed to be anti-competitive. So, the Hawaiian transaction, Hawaiian is not considered a low-cost carrier, and the competition was with the big four, not with the ULCCs or the low-cost carriers. So, any uniqueness that Hawaiian brought to the market was in its brand and in its culture. It has a vacation vibe to it, right? People want to fly to Hawaii on Hawaiian for the experience and the quality and the service. But that uniqueness wasn't going away with the Alaska transaction because the brand is going to be kept going forward. So I think that's maybe one of the key differences is the markets that they served and the breadth of competition in those markets was very different in both deals. And the DOJ did not have confidence, apparently, in the JetBlue Spirit that others would come in and restore that competition.
Right. And I think we're going to turn to David to talk about DOT and in the context of Alaska and Hawaii. But before that, just to clarify, David, did DOT play a role in JetBlue Spirit?
Only to a limited extent. And maybe a little context on how the DOT review of mergers would help here. After a proposed merger or acquisition has been announced and the DOJ review process has begun, the merging carriers typically will file with DOT the application for approval of the certificate and route transfer authority that I described before. In JetBlue Spirit's case, they went ahead and filed that application fairly early on in the process. And historically, DOT has not acted on those applications until the DOJ review reaches some outcome, a positive outcome, a clearance or resolution of any litigation. In JetBlue Spirit's case, immediately after DOJ filed suit to block that merger, DOT took the very unusual step of, first of all, issuing a press release stating their support for DOJ's position and their intent to deny an application that JetBlue Spirit had filed. And then a couple of weeks later, they went ahead and issued an order denying that. It's actually two applications that get filed, but the first of the two, they denied it without prejudice, but it really came across as an act or gesture on DOT's part of support for Department of Justice's position and sort of a statement that they would not be doing anything to facilitate the transaction moving forward, at least until the litigation was resolved. And of course, ultimately that litigation, led to blocking the transaction and didn't go forward. So DOT wasn't put in the position of having to take any further action.
Going back to DOT, the DOT played a role in the recent Alaska-Hawaiian merger, which is a little bit unusual. Could you please give us a bit more context as to how the DOT comes into the picture in terms of reviewing merger of airlines?
So, I mentioned before, the DOT has this limited authority to approve transfers of the DOT-issued certificates and route authorities that carriers hold. And similar to the filings that JetBlue and Spirit made in their case, Alaska and Hawaiian on July the 15th of 2024 filed two applications with DOT. And these are applications that get filed in a public docket. The first application is formally the application to approve those transfers. And consistent with past practice in other airline merger cases, they also filed an application for interim exemption authority. And the way the process typically works is that once the DOJ review process is resolved, obviously and when I say resolved, I don't mean as in JetBlue Spirit's case, I mean in prior cases where the HSR process would conclude, or even if there was a lawsuit filed as in American US Airways that got settled, the request of the parties to DOT at that point would be to issue an interim exemption, which is essentially a placeholder approval that affords the parties clearance to close their transaction without fear of running afoul of the fact that DOT has to approve route transfers, and gives DOT the opportunity to defer their full review of that route transfer application until after closing. So in the Alaska Hawaiian case, as I mentioned, the two carriers filed their applications with DOT on July the 15th, 2024. And after the DOJ review process concluded, there was a period of a couple of weeks before DOT ultimately issued an order approving the exemption, and Alaska and Hawaiian closed their transaction the next day. What was different about Alaska Hawaiian is that in prior cases, when parties, let me put it this way, got clear of DOJ, DOT would typically issue that exemption approval within a day or two. In Alaska Hawaiian's case, DOT did something very different. They invited Alaska and Hawaiian to engage in discussions that led to the signing of an agreement between Alaska Hawaiian and DOT on certain quote-unquote commitments, written binding commitments for Alaska and Hawaiian to provide certain assurances, do certain things post-closing of the transaction. And a couple of those commitments are competition-related, many of them were not. And from a DOT policy and precedent point of view, this was quite a significant development, because for all of those years since 1989, when Congress took that merger approval authority away from the prior agency and left DOT with this more limited route authority approval, DOT has consistently interpreted that public interest standard very narrowly, and typically approved those route transfer applications. And in this case, this was a very significant departure, and one where DOT had not signaled it in advance with any sort of statement of a policy change. And so, it's unclear what this portends for the future, whether DOT at some point will formalize the policy change that, at least under this administration, they have effectively made with the novel approach to Alaska Hawaiian, or whether they'll revert to prior precedent, which, as I mentioned, involved a much more limited scope of review that was not significantly focused on competition issues.
Right. And I think we're not here to ask you to speculate, not for future or for the past, but what could have driven the DOT's departure from its precedent, and what, could have caused this, I guess, a little bit of a heightened scrutiny from the DOT part?
Well, it didn't come out of nowhere, in the sense that there'd been a fair amount of speculation as to what this DOT's approach to reviews of route transfer applications would be. Senator Elizabeth Warren, sent a letter to around the time of the announcement of the JetBlue Spirit transaction. It was a fairly lengthy, detailed letter in which she argued that DOT has been underutilizing its statutory authority when it comes to mergers, and suggested that DOT's authority was closer to full-blown authority to review all aspects of a merger transaction or competition implications. In effect, the prospect of a second review after DOJ, the theory being that the term public interest can be read broadly enough to conclude that DOT has that type of authority. That flies in the face of something like 35 years of DOT precedent. But the idea was out there, and there was a lot of a speculation as the JetBlue Spirit transaction went forward that if JetBlue Spirit were able to clear DOJ, what DOT would do in that case. And as I mentioned before, that became a moot point after the outcome of the litigation. So on the DOT side, the Alaska Hawaiian case is really the case of first impression. And as I mentioned before, what's interesting about it is that there was no advance notice of a change in policy. No rules or regulations were adopted. And to some extent, this is still an open matter, to the extent that, as I mentioned before, that the exemption has been approved. The route transfer application remains pending. And that's consistent with prior DOT practice, as I mentioned, that DOT often takes months after the closing of a transaction to rule on the merits of a route transfer application. But when DOT does it by means of a published written order. So it'll be interesting to see how DOT deals with those issues when they issue that order, which, again, may be months away.
Right. No, we're actually asking you to speculate. So do you think the DOT would be actively involved in the review of future airline mergers? And are they here to stay? Is this a change for good, or is it not so much in your view?
Well, that may be a political question in terms of where the leadership of the Department of Transportation may go. One thing I will say on this subject is I think DOT has a strong history of transparency about its policies and its interpretations of its statutory authority. It's issued an extensive body of rules and regulations. It's also historically issued a large volume of policy guidance. And the last policy guidance that DOT issued on airline mergers and acquisitions comes from 2015. It's a fairly brief document that really recites the statutory authority in a sort of a summary fashion, and then emphasizes DOT's consultative role with respect to the DOJ, but it doesn't provide detail about how DOT, as a policy matter, would propose to interpret that authority on the route transfers. And I think, frankly, the reason for that, at least at the time and until the Alaska Hawaiian transaction, was that there was a very well-established and consistent body of case law at DOT interpreting that route transfer test. And DOT, in the brief order that it issued granted the exemption, didn't get into a discussion of that line of cases and whether DOT was taking a position where they were departing from that precedent and explaining that change. I would hope, as a practitioner, that they'll do that at some point if, as your question anticipates, this may be a longer-term change of position and policy.
So I'd like to transition now from talking about the federal agencies to talking about the role of states. And I used to be a state AAG and antitrust, so I definitely want to make sure we talk about the state's role. So what states were involved in reviewing the Alaska-Hawaiian merger?
In the Alaska-Hawaii merger, the state AGs of Washington, Oregon, California, and Hawaii participated in the review.
And what about JetBlue Spirit? I know you weren't involved in that one, but do you know what states were involved in that investigation?
So I do know, based on who joined the DOJ's complaint, the Attorney Generals of Massachusetts, and I know that, and this is a public document, the parties separately negotiated agreement with the state of Florida, which was a state that had a vested interest in this transaction. And so they had a separate kind of settlement agreement that the parties made some commitments to the state of Florida if the transaction were to close. So I don't think Florida joined the litigation, but if the transaction did proceed, this agreement would come into effect and they would have to make these commitments to the state of Florida.
What did the state's investigation look like? How closely did they coordinate with the DOJ or the DOT?
So that's a little bit of a black box to the parties. What we can say is, how often they reached out to us. They certainly participated, or at least listened into depositions in the transaction, meetings and advocacy that we would put on for the DOJ. But in terms of separate contact with the state AGs, it really only was with the state of Hawaii. And that was more of a concerted effort on the airline side as well, knowing how important Hawaiian Airlines was to the state, to its economy, to its residents. So we wanted an open dialogue with that state AG to make sure we addressed concerns they had both on a competition side and otherwise.
And then speaking about the importance to Hawaii, the governor of Hawaii announced that Alaska Airlines reinforced commitments to the state, including maintaining Hawaiian Airlines brand and preserving jobs in Hawaii. So how was this accomplished?
So, again, from the beginning, Alaska was very clear. There was commitments it was willing to make to the state and to Hawaiian Airlines as part of the transaction, which included maintaining a hub in Honolulu, maintaining a significant presence in Hawaii, maintaining and growing jobs in Hawaii, preserving the Hawaiian Airlines brand. So the commitment that the governor was referring to was along the lines of the commitments that we already had made publicly. It is a confidential letter at this time, so I can't get into the details, but it was very consistent with what the governor announced in his press release, was the commitments that the airlines had made to the investment community, to the state of Hawaii, to its guests about what it intends to do with flying in Hawaii. And so it was accomplished through an agreement with the AG. So in terms of the commitments that Alaska Airlines made to the state AG was through a letter sent to them reinforcing the commitments that were made publicly on the joint airlines website to the investor community through our investor decks and through our public statements.
Sounds great. So we definitely had a very rich conversation about merger airlines so far, and seems like this is a space to watch. I would definitely be watching, especially when I'm booking for holiday trips. Before we let you go, we do want to learn a bit more about you, David and Courtney, on a personal level. So what we usually ask our guest speakers, and we do ask you today, is that could each of you tell us a little bit about yourself that we would not know if we had only been knowing you in a professional setting?
You want me to go first? So I guess it was something that I think you wouldn't know about me in a professional setting, but I think that's now been blown, which is my family and my close friends call me Coco. And for some reason that slipped out during the review of this transaction. And so now, my friends at Alaska Airlines, from their legal team to their executives, have started calling me Coco. So it might be a time for a professional name change.
Yeah, we're actually all on Team Coco, as it's referred to.
Team Coco. Well, that's definitely a very fitting name for that matter you worked on. David, tell us a little bit about yourself that we don't know if we only work with you in a professional setting.
So, well, you might have guessed that I'm not originally from the United States. I'm actually from Ireland. Grew up there and only moved to the United States in my 20s. And to sort of follow through on the line of Courtney's discussion of nicknames, when you're from Ireland, nicknames are not something that you could really refer to on a family podcast like this.
Oh, really?
He's going to still keep us guessing, I think.
Yes.
We do broadcast very, very widely. So yes, for the benefit of listeners who we're not going to have you reveal that name. Okay, it's a wonderful conversation. We're happy to have you on, and this is apparently a space to watch. We might have you back in the future. And listeners, thank you for listening.
Thank you.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.